Well, welcome back to the Cordell and Cordell Virtual Town Hall. I'm Scott Trout, Managing Partner and CEO of Cordell and Cordell. We're glad you joined us. Keep in mind, we're going to go ahead and present the topic, which is modifying your divorce decree. It's always, when do I do it? How do I do it? It's always the age-old question. We talked a lot about that during COVID in 2020 because it was something that was pressing on many, and we'll try to unlock some of those mysteries, but we also want to talk a little bit about celebs, because that is always in the news. And we're going to talk about Kanye and Kim, a big article that was on the Daily Mail, in their use of social media, because I think we can always somehow figure out a way that our facts and circumstances wind up in public and celebs, and they have some of the same issues that you and everyone else does. So we're going to talk about that also. Keep in mind, you have some questions that have been submitted. You can always do those by going to the Q&A section of this town hall. We're going to address those questions for you, try to get you answers in the second half of our town hall. So do that now. Submit them in the Q&A section. Just give us your first name. Don't give us much more information, maybe the state in which you live. We'll try to give it to one of the panel members if we're lucky enough to have one in your state. Now, keep in mind, we can't give legal advice here in this virtual town hall. This is educational, informational. Many of us won't be licensed in the state in which you reside, but more importantly, the only and the best way to get some sort of advice is doing a consultation. You can do that at 866-DADS-LAW if you want to have one with one of us. You can do it virtually like this, in person or on the phone, whatever works best for you. But keep in mind, that is the only way to get legal advice, is to have a consultation or develop a relationship with an attorney. And we always say, find one that practices exclusively in family law like we do. So again, Q&A section. We have some questions that are rolling in. We want to make sure you can get those answers and give you the right direction that you can as we progress through today. And we'll try to get that in the second half of the program today. So let's introduce our panel of Cordell and Cordell attorneys for today, and then we'll get right at it. First, Lauren in Dallas, welcome.
Hi, good afternoon. My name is Lauren Gilbert. I'm a litigation associate in our Dallas, Texas office. I'm celebrating my 3-year anniversary this year. And this year I've been selected to Rising Star by Texas Lawyer Magazine.
Thanks, Lauren. Let's go over to Arizona and the Phoenix Metro, Scottsdale, Peoria. Chris, welcome.
Good morning, Scott. Christopher Kennedy here. I practice in Arizona out of our Peoria office. I'm a lead litigator with Cordell and Cordell, and been with the firm almost 5 years now. Glad to be here. Thank you.
Thanks. Let's go ahead and go to Illinois, Belleville, right across the river here in St. Louis. Krista, welcome.
Hello, everybody. My name is Krista Jones-May. As Scott just said, I am practicing primarily out of the Belleville, Illinois office, but I dabble up near Cook County as well. I've been with Cordell for a little over a year now, and I'm excited to be here. Thanks.
Thanks, Krista. Let's round out the panel of the Cordell and Cordell attorneys for today. We're going to Baltimore. Arnett, welcome.
Good afternoon, everybody. My name is Arnett Mumford. I practice out of our Maryland offices, primarily out of Baltimore, but we service clients throughout the great state of Maryland. I'm also a barred attorney in Georgia, Florida, and the District of Columbia.
Thank you. All right. So again, submit the Q&A questions. There's some already rolling in, and we've got a bunch that we'll handle in the second half. Let's go ahead and do that. But first, let's go to a quick commercial break, and we're going to get right at it.
For many men, divorce casts a long shadow across every part of their lives. Your usual routines and familiar places are no longer inviting, and time spent with friends, even family, is no longer comforting. But you don't have to walk through this alone. We can help. For more than 30 years, Cordell and Cordell has guided men through the challenges of divorce. You're not alone. Call Cordell and Cordell, a partner men can count on.
So keep in mind, you can reach us at 866-DADS-LAW or CordellCordell.com. You can find more information. We have offices around the country, including the United Kingdom, and you can go to CordellCordell.co.uk for our viewers in the United Kingdom. So let's talk about it. I want to open it up to our panel. Oftentimes we find ourselves with an interesting topic in the news, and Kim and Kanye have clearly given us more info and more to go with over the last number of months, and their lives have been pretty much right in the spotlight, and today, no different, which is kind of a subject matter that's near and dear to my heart, which is social media. This dates back to, I've talked about where I was on Dr. Phil as the expert of the day, talking about social media well in the beginning of, social media, when we started, before probably Instagram, before Twitter. Facebook had just started. And this is no different. If you can go to, like, I was looking at the Daily Mail, the title is Kim Kardashian and Kanye Go to War Over Kids, basically on TikTok, which is something new, even for divorce lawyers, as we navigate social media. So I think let's start there. Really, Krista, I'm going to start with you. I always talk about social media with clients. It's one of the first things I address. Talk about your experience. Is this something, what do you counsel them on in terms of social media, using it before divorce, during modification? Kind of what is your thought process as it relates to even looking at this article with Kim and Kanye?
First and foremost, I think that the biggest takeaway here, and the biggest takeaway as far as social media goes when I am counseling my clients, is remember that everything that you put out in writing could potentially come back your way. My standard is generally, if you do not want to read that post out loud to the judge, you may not want to post it. In Kanye's case, I think that he may potentially have no issue reading those things in front of a judge. So then you sort of play in the gray area of social media and what is acceptable and what is not acceptable in the court's eyes as far as presenting opinions about your children or your spouse or the court process. And that can complicate the judge's opinion of you when making rulings in your case.
I mean, it's so true. I mean, I think about, I'm always telling clients, really think twice about using social media. I rarely find that it's beneficial, that a post that you make is going to help you. Rarely. We can find other ways to help you, whether it be in photographs or other things and time spent. And so, Christopher, I'm really curious. Let's just assume for the moment that we have social media, like, for example, Kim or Kanye may want to use it. How would they go about using it to their benefit to argue their case? If they, for example, let's just take Kanye. He's angry that they're using, their daughter, or Kim's using the daughter on TikTok, and really talking about the divorce. And how would you go about using it in a divorce or modification?
That's a good question, Scott. I think my first advice would be not to. As far as posting, I would be very strategic in what you would post. I understand that as a celebrity or even as a dad, in a custody case, that you might want to win your case in the court of public opinion, but it may very well cost you in the actual court. So if you're trying to argue your case, my advice would be don't. I would monitor the other party's posts and certainly keep tabs on those, take screenshots. That can be very good ammunition to use in a court of law. But as far as I would go along the lines of advising, the less you say, probably the better.
Yeah, no doubt. I mean, I've gone so far as to say, look, let's just turn off social media. Don't go deleting your account. Don't go delete posts. It's the last thing, you want to get caught up in, is if you're destroying evidence. It's just take a break and tell your friends not to tag you. So Lauren, let's talk a little bit about this involving your kids. Clearly, there's a way to do it. And I think maybe what rubbed Kanye wrong was, and I was kind of going through this article today about how Kim, kind of her original post was, hey, I'm in the middle of a divorce. I've got my child with me, kind of intimating, involving the child, not only in the case itself, but then using a national worldwide platform to kind of just broadcast it. Certainly, it's one of those things where you imagine you have to counsel your clients, whether it's divorce or modification, about using and involving your kids on social media.
Yeah, absolutely. So especially in their context, most people don't really care what my 4-year-old is posting on Facebook. Not that she does, but when you're dealing with celebrities, you've got something that they can sell too, and marketing your brand. And we all know the Kardashians are very much about their personal brand, and so that is something that is actually a litigatable issue. Is the rights to services and earnings of the children and managing that. And that is something that can be hotly contested. And when parents have differing views, that's a decision for the judges to decide. And with Kanye, I understand his frustration, and that's something that, the parents should be, deciding and trying to reach a joint decision on. But, part of his problem is that he's broadcasting to the nation and making all this a big public display. And guess what? Your kids, if they're not on social media now, they're going to see this later. And this is an issue that relates to most normal people like this, where our lives aren't a matter of public opinion, but the internet is forever. And these kids, they're going to be able to see these public displays between their parents, if not now, in the future.
Yeah, and kind of rounding out, I mean, I know I want to get into, because some of this topic, why I think it's so relevant, is we're talking about modifying. We're talking about whether it's modifying custody, visitation, support. We're going to get into all of that. Arnett, I kind of want to round it out with you. And that is when we talk about just as saying, using it in a modification case. And I was just reading this article, Kanye's talking about how divorce is difficult already. They've got 5.5 million followers, together between them. And you've got Kanye saying, look, I don't approve of this. I was just looking through kind of what his statement was. And I don't think that's something we should be doing. And so I guess the question becomes, it says, I'm not there to approve of that. And they're trying to share custody. So Arnett, I guess the question is this something you think ultimately, now theirs is different because it's divorce, but obviously we're going to get into some of the standards, and the evidence is evidence. I imagine it's something that could be used to argue maybe questionable parenting decisions in a modification case, I imagine.
Well, I think you can definitely use and look at parenting decisions. I say social media can be a dual-edged sword. On one case, having these public declarations as Kanye is doing, he might not necessarily be using it in the most effective way, but it is a way to establish very publicly a stance on his issue. So at a later point, if opposing counsel or Kim says, you told me that it was okay for me to do it, he can say, well, I've made this known. Millions of people know this is my standard. Again, unlike other counsel have said, I would counsel any client, whether it be an email communication or a communication via social media, to really think long and hard about anything you're putting in writing. As a former member of the judiciary, we do read everything. So you will want to make sure that if you're sending something out, sleep on it, make sure that you edit it, proofread it, make sure that it's something that you strongly want to convey, and make sure that you're conveying it with a cool head. I believe the danger with social media is that the ease of transmission is so easy that we can send things when we haven't had adequate time to really think about what we want to say, how it's said, and how it's reflecting. And I think you can really see the difference between the transmissions of Kanye, who's probably doing his own tweeting in real time, versus the very lawyer-esque response that was delivered by Kim. And you could tell that although it may have been crafted by herself, I have an idea that she had a lawyer or some sort of a confidant to review it and craft it. So the wording was very intentional in the way that it can be read and digested by a court or any type of arbitrator in the future. So that would be my advice.
Yeah, I think you make a good point, Arnett, at least, from your experience, in the bench. And I think the point is that you're right. I think a lot of posts are emotional and they're not thought through. And as a result, it's not kind of what you would approve of. For us as attorneys, representing, you'd love to have the ability to, as maybe you suggest, Kim may have had someone review it and approve of the post. And maybe it's baiting Kanye to come in and engage in this online war. But I think that's the point that I've always made with clients is like, look, the one mistakes that every guy make, the one mistake is that they react on emotion. And as a result, there's a consequence. And sometimes logic goes out the window in divorce and modification, and you just say stupid things. And so that's why I think it's just not the right platform. So I know we could probably devote the entire hour to talk about Kanye, but we're going to kind of move on and let's get into the heart of the matter. And that is really modifications and when and where and how do you do it? Kristen, we're going to start with you. That's the best way to let's set the stage. We've got a number of questions already coming in, so we'll have plenty of questions at the end. Modification. What is the standard? And I know the standard is going to be in large part, there'll be nuances across the country. And so we encourage people, obviously, check in your state, but in Illinois, what is the standard to modify, in your state, whether it be generally modifying a divorce decree?
In general, in Illinois, our standard to modify any of the existing court orders is a substantial change in circumstances. So that would mean that when at the time of the entry of your initial order or the order that you potentially previously modified, you're going to have to show the court what has changed such that it's going to require the court to see the need to change what your kids are doing. Because as I like to remind my clients, yes, this is a process that is driven by you, but the court's focus is a lot of the times going to be primarily focused on the kids. I know in my jurisdiction, the courts tend to want to modify as little as possible because they want to limit the exposure of change to the kids. We call it maintaining the status quo. So when people come to me looking for a modification, I have the who, what, when, where questions. It's important for you to be able to articulate exactly what has changed in your life or in your kid's life or in the opposing party's life. So you can show the court that the need is there for the modification to happen.
We've talked about, and that's a good point. We've talked a lot about, and I've argued on appeal, at least in Missouri, and that is there's some words in the Missouri part, which is as you mentioned, a substantial change, but ours is a substantial and continuing. And I think, that's a key word where I've argued that was a brief, it was a temporary change, something that wasn't continuing in substantial nature. And I think, the point is it shouldn't be sudden. It's not something that just appears, and that requires preparation. It requires, we've talked about it, whether it's 10 stupidest mistakes guys make, it's prepare. And obviously, detailed notes, so you can present it to your attorney and ultimately to the court, right?
Absolutely. Preparation is key. A lot of the times on the divorce side, it is harder to prepare. A lot of people feel caught off guard. On the modification side of things, you know what's expected of you, and you probably know where you want to get. So generally speaking, yes, there are emergent situations where a modification of an order would have to be in place. But most of the time, these things happen a little piece at a time, changing over a significant period of time. So I recommend keeping a calendar, keeping track of dates and those minor nuances. Keep your text messages, emails, social media posts, all of those things that you think are going to help you prove your case. Keep those, because that's going to help show the court why you think there is a substantial change in circumstances.
And often, like you say, this occurs over years. I'm just counseling with someone now on a modification that has taken 5 years to evolve. And, at the end of the divorce, many want to just be done with it. And obviously, if you have money, obligation supports, or kids, it really begins the process in the period of accurate notes, a day in the life, what's happening, keeping good calendars. And that way, when you are ready, you're organized in a coherent way to present a modification case, because you have to meet those burdens of a substantial and perhaps a continuing change of circumstances. It couldn't be just last month, well, this happened, I took a decrease in income, but next month my income's going right back. Those are the kinds of things. And I think that it's kind of an odd standard to understand. But I think as you think about custody, if you want more time and you've had more time over the last 3 years, let's just say you were getting one night a weekend and every other week, or one night a week and every other weekend, but you've had equal time, you want to have a calendar, right? To show to the court what's happened over 3 years.
Yes, I think that is absolutely spot on. Calendars are definitely your friend. Usually we see those small changes. Usually it starts as you get an extra day. Maybe your weekend was Friday to Sunday evening, and you've started exercising that Monday overnight, overnight into Monday. So that's going to help. In Illinois, it will potentially help for child support purposes. You can get to that next threshold for lowering your child support obligation.
Absolutely. And, one of the things I know, I'm sorry to interrupt you. I know
you're
that
okay.
we talked about Kim and Kanye, and maybe we've done this before. When during COVID, we talked about stars and ignore their assets, ignore their crazy, property disputes. I mean, there's something to be learned from Jeff Bezos. There's something to be learned from Kim and Kanye. And people always say, well, why do you talk about it? This is a great one. And just wrapping your subject up, leave comments off social media. I mean, that's the point of talking about Kim and Kanye. They just need to be stopped. Stop talking on social media. You're exposing your case. You're causing yourself damage. You're not helping. Imagine kind of as you talk about the standards and kind of what you need to do and preparing for modification. That is, stop berating your ex. Stop berating your kids or opposing counsel, right, on social media.
Absolutely. I would echo again and say, if you do not want to read it to the judge, if you are uncomfortable reading that post out loud to the person who is going to make decisions in your case, you shouldn't be posting it on social media. One of the things that I also tell my clients is you should probably not talk about the opposing party at all on social media. But if you are going to do it, make sure it's in a positive way. One of the other panelists, I believe it was Lauren, said that this is going to be in existence forever. At some point, your kids are going to read this, or they may read this. You don't want that to come back toward you and have your kids then think of you in a more negative light. For Kim and Kanye, North is young right now. She's 8. She's probably not testifying to the court as to what she would prefer to do. But at some point in her life, that's something that if there's a modification in the future and she's old enough and the court is willing to do that, if those are opinions that she's read about her mom from her dad, it could skew her desires as far as how the case would be resolved. And so, yes, there's the emotional aspect of divorce and modification that cannot be ignored in these types of cases. But taking a step back and reviewing what you're going to do, but also thinking about how it's going to impact you in the future. Yeah. I'm also a big fan of type it up. Type it up. You can send it to me. Send it to me. I'll read it. We'll have a good chuckle. And then we delete it. We forget that ever existed.
Right. Absolutely.
But don't post it to the public.
Right. Lauren, let's kind of, we're going to get technical because a lot of people, when I meet with them, they do want to relitigate some of the issues that were in the divorce. They want to talk about things that the judge already decided or things that were available at the time of the divorce. We call that resjudicata, a Latin term. Let's talk about, I would like you to talk about resjudicata. And again, we mentioned the substantial change in circumstance, material continuing. I know, in your state, it's probably a little bit of a variant, but maybe you can talk about those because inevitably that's going to matter to guys listening right now. Talking about things that have been decided, what we call res judicata, and why you can't bring it up. So maybe you can start there.
All right. Well, yeah. So res judicata is just this general legal standard across the board. And what it means is that a matter that has already been decided by the court, you cannot pursue that issue further with the same parties. So that's just a general legal standard. The thought process behind it is generally judicial efficiency. And so typically, especially in modification context, so we can't be, if we're looking at, all right, here's the date of divorce, here's something, you can't point to something that happened about 6 months before the date of divorce, or even the day before the date of divorce. The court, or if the parties reach an agreement, all the facts and circumstances that existed at that time, those are all part of the consideration of factoring into what happens with these orders. That's all factored in at that point. And so sometimes what ends up happening is you find out something after the fact too, that, well, you had the opportunity to look into it, maybe perhaps through the discovery process, or you didn't necessarily want to blow things up and bring up an issue, but now you want to bring it up later, that's not going to fly because you had that opportunity in your first case or the prior case to bring that up and you didn't. Either you agreed to the order as it was, knowing, oh, hey, this person's work schedule sometimes causes conflicts. But that going into it and you agree to this anyway, or the judge heard that evidence and said, I don't think it's that big of a deal. I'm going to order this anyway. So looking at the factual circumstances as they were then, you can't really do that. And I think you'll find by most of the speakers, what the legal standard is, if you're wanting to modify, is some variant of this substantial change. In Texas, you're generally looking at, our phrasing is material and substantial change. So kind of like Scott said, continuing. It's not just a, hey, here's a one-off or two-off type deal, but something that significantly impacts what the court ordered that, is good reason for changing that aspect of the court order. It needs to be related to what you're asking the court to change.
I think I want to real quickly on backing up on Resjudicata. The way to easily describe it is, I was just thinking about golfing. That you golf today out of a tee box, and tomorrow the tee box moved forward or it's moved left or right. It's a new starting point. It's almost not that it's wiped clean, but that sets. I've explained this to a client the other day. Is we have a new floor. And now the floor has been raised because here's the divorce and here's the floor and the standard. Well, she was an alcoholic at the time of the divorce and she's still an alcoholic, but maybe no worse and no better. So, but that evidence was there, and maybe if it's new, you can raise it, but you can't just say, well, she cheated on me in the divorce and before we were married. And I want to argue that now still. That's always a great example. Exactly. And to do that, but substantial change in circumstances. I know it's in material. You use the word material, right?
Right.
And so what does that mean?
So it's going to be a case by case, situation. So something that might be material in one case might not be material in another. So, for example, like I mentioned, hey, periodically this parent lets me have these overnight periods of possession. And so, we've been trading off by agreement on a few occasions. Is that enough in the grand scheme of things to say, hey, this should be changed ongoing? Or was it just a, hey, I was covering for you type deal? Or, someone's job, their schedule changes a little bit, or there might be a relocation. Well, if I relocate maybe 10 miles away, is that substantial enough of a change on the parenting plan logistics? Or versus, if you move 100 miles away. So it's hard. There's not going to be a black line, hey, this is a material substantial change. The court's generally going to be looking at what is the overall effect. There's often little things that add up to cause a material substantial change.
So I think, what's interesting is we talk about the material nature of it. Let me ask real quickly, and then I want to move on as we have a lot of questions that have come in. The question becomes is what can be modified? Because there's always a question, maybe just the topics of what can and what cannot be modified from the divorce. Don't worry about the standard and the content, just what can and what cannot be modified.
Okay, so in Texas, property division, so who's getting what bank accounts, retirement accounts, who gets the house, property divisions cannot be modified. So you want to make sure you get that done correctly the first time. We don't have alimony in Texas. We call it spousal maintenance. So that depends if you are receiving spousal maintenance as allowed under the Texas Family Code, or if somebody didn't necessarily qualify, but they still want to, reach an agreement for what we call contractual spousal maintenance. Most of the time you can't modify contractual spousal maintenance unless you agree within the confines of that provision that it's modifiable. The court in general does not have the authority to modify contracts between two parties. So that's an important distinction, because sometimes parents can agree to other contractual provisions regarding their children too, above and beyond what the court can necessarily order. So sometimes parents want to agree to like college expenses. In Texas, the court can only order child support for when the kids are under 18 or still in high school. But if you're doing contracts for college expenses or talking about like taxes and things like that, since that's a federal law issue that the state divorce court does not have the authority to order. Contractual agreements, the court cannot modify those, and the court cannot modify property division, but the court can modify spousal maintenance within the confines of if somebody qualified for spousal maintenance under the family code. The court can also modify what we call conservatorship and possession access, so what other states call custody, as well as the court can modify child support.
Thanks, Lauren. Christopher, I want to go to you. And I know some states in particular, when it relates to modifying child support, I have a lot of guys that come to me and say, well, I've heard I can't modify any time until 3 years have passed, which is not accurate. But some states do have a general guideline when it relates to requesting a modification. Some want to go the very next day. They got divorced and tomorrow they want to go tomorrow. I mean, there may be the facts, we'll support it, but I'm not so certain. So the question is, in Arizona, is there a general timeline? Is there law that says you have to wait X number of days between modifications or divorces?
Yes, Scott, actually, there are. And it depends on what kind of modification you want to do. So like Lauren had said, in Arizona, the property issues, bank accounts, property, real estate, when it's done, it's done. But custody issues, legal decision making is what we call legal custody here in Arizona, and parenting time, which is what we call physical custody, and child support are almost always modifiable with certain guidelines. So according to the statutes in Arizona, generally, if you have custody orders, you can't modify those for a year after. So let's say you get divorced, you come up with a parenting plan, you're stuck with that for a year, statutorily. Now, there's always some exceptions to that. Obviously, if there's a danger to the child, some emergency that would put the child at imminent risk, you could do that as an emergency almost the very next day if that comes up. Other issues, like if someone's violating the order, you can bring that up before the year, but you still have to wait 6 months for something like that. And then child support, technically you can modify that at any time. There's no time limit for child support. However, there are certain qualifications before you could change that. So one example would be, you have to show that the new child support amount would be greater than or less than 15% of what the current child support order is. You'd also have to show that you did have some kind of change in circumstances. Now, for child support, the standard is lower. You don't need to show a substantial or necessarily even a continuing change in circumstances, but you need to show some change, like change in employment, change in marital status, the birth of a new child or growing your family, emancipation of another minor, even as something as simple as availability of health insurance for the child. Those are all reasons that you can go and modify child support almost immediately.
And I think that's, guys watching, you want to ask an attorney in your jurisdiction, in your county, in your state, hey, what's kind of the standard? Because it goes across, as you say, you've got this statutory requirement that may not exist anywhere else, and you just have to meet a standard. So encourage everyone to do that. But generally, as we keep moving along, Christopher, talk about what guys should be thinking about in preparing for their case, whether it's, modifying, custody, where it's modifying support along with that, or maintenance, spousal support, alimony. Kind of what should they be thinking about in preparing to support their case?
I think first and foremost, Scott, you really need to know what your current orders are. I know you get divorced and it's a blur, or you modify orders and you think you know what you agree to, but really before you get started, you need to look at those orders or consult with an attorney and say, what does this mean? Like, what exactly is my order? Sometimes you get people thinking that, oh, you've been following this thing, and that's not actually what was in the order. So you want to know what that is inside and out, and know, at least here in Arizona, if you want to change something and you can't agree, until the court makes a decision, you have to stick with what is in the order and do that. So I would start with that. I generally, specifically in Arizona, but I think generally too, you really, in preparing for your case, you need to show that you are able to, or at least have tried to communicate with the other party, with your ex. I know you probably don't want anything to do with them, or as little as possible, but what the courts, at least here, want to see is that you are at least making an effort to co-parent with your other parent. That means you have to try to discuss these things first, and see if you can resolve it that way, or at least show that you have made that effort. That will go a long way in preparing for your case. Again, like everyone has said here too, keep good records.
And therapists, I think that we talked about yesterday, I was in a case, I talked about a vocational rehabilitationist, something, utilize as many experts as you can get to support your case. Anyone that is away from a he said, she said. I try to say, look, I don't want you to be the only thing that the judge relies on, because you have, a vested interest in what happens here. I want someone else to kind of give us an idea, or a therapist, or a counselor, a psychologist, an accountant, anything that can help. Yeah, I imagine that's something you want to also consider.
Absolutely. Again, for record keeping purposes, a good accountant, someone that's going to be able to get your, financial matters, in order, that's going to go a long way in modifying your child support. Likewise, if your kids are in therapy, or if you are, you want to, involve that therapist in recommendations, or at least records. There's good professionals. I don't want to say bad professionals, but you want to think long and hard too before you involve other professionals like the police, or we call it the Department of Child Safety here in Arizona, DCS, CPS, whatever you call it in your state. That could be a double-edged sword. You might think involving an agency like that in some issues would, make your ex look bad, but it can backfire.
Yep.
In the extreme cases, it can really affect your ability or your access to your children as well. So you want to sort of be cognizant of what professionals you really want involved in your case, because in a lot of circumstances, once you involve them, you can't get out of it.
Yep. Arnett, let's kind of turn to you. I want to round out the topic on modifications. Let's talk about physical custody, visitation, physical custody, whatever the terms are used in the states that guys are listening in, and maybe walk through what the court would want to see in order to entertain a modification when it relates to kids. And then we can kind of transition beyond that.
All right. Well, I believe I echo what my colleagues have been saying. The court is going to look at two basic standards. One, to see whether there is a material change. And that's pretty much to say the court is looking at your order, or the order, whether that be an order for visitation, custody, anything. They want to see, has anything significantly changed? And then they want to see if they do find that there's a change, is whatever that's going on, is it going to be in the best interest of the child? When you're dealing with visitation, when you're dealing with custody, when you're dealing with access schedules, even though something has changed in your life, you still have to make sure that you're taking into account the lives of the kids that are being affected by these decisions, and making sure that the proposed change is actually going to benefit their lives, and the court's going to determine that it's in the best interest of their lives. Like they said, the court generally tries to keep things the status quo. It's almost like the old saying, I'm originally from the South, they say, if it ain't broke, don't fix it. So the court really doesn't want to be the person that is squashing petty beefs between parties. They want to make sure that if the visitation is working, there's been no issues, there's been no dust ups, the kids haven't gone to the ER, there's been no family violence issues. And if it's working, the court generally doesn't want to break something that is currently working. So you would really need to think long and hard about, why do you want the change? How is that going to affect all the parties? And two, do your kids even want that change? Because as your kids grow older, a lot of jurisdictions will actually bring in the kids and say, hey, Timmy or Janet, what do you want to see? Now, certain states are bound by those decisions. I know in Georgia, they tend to take that into consideration. However, in Maryland, they will consider that as a factor. So if you're 16 or older and your client's child says, I want to be with mom or I want to be with dad, the judge is going to really take into account what they say. So before you come to an attorney, you might want to ask your children, do you want more time with dad? And really know what their questions and their reasonings are, and make sure that you know all the factors that are around. And I would say, make sure that you, before you come and try to modify it, that you actually read the order, especially if you have a order that was resolved as with what we call a marital settlement agreement. It could be it's like a contract. A lot of the contracts or the marital settlement agreements actually have provisions in there that say, if you can't agree with mom about visitation, or if there's a change, what steps do you need to go through? If your agreement says that you have to go through a mediator, or that you have to discuss it, and you bring an order for modification and the judge says, okay, I read your order, did you go through the 2 modifications? They're just going to throw it out. So you have to make sure that you're making a good faith effort to resolve a lot of the issues. I tell my clients all the time, you're free to come to an agreement with your spouse if it's a small change. If you want the kids for an extra hour, you don't need to involve the court. So you have to make sure that you're trying your best to do everything that you can to resolve these issues before you bring it to the court, so they will entertain your plea.
And kind of wrapping it up in the last, before we get real quickly to the lightning round, we have a lot of questions. Arnett, I know there's questions, kind of went through them about, how do I modify child support? Can I modify? Can I modify spousal support, alimony, maintenance? Generally, just go through quickly, what do you think the standards are, especially in Maryland, as it relates to the modification of child support and maintenance or alimony?
Okay. Well, in child support, generally the court wants to see that there's been some significant change in one party's earning capacity. While there's not an official percentage, I know generally if a parent were to go to the Department of Child Enforcement, they generally won't take on your case unless there's been a 25% change in your income. That means saying, if you find that your spouse got a $1 raise, probably not going to be worth your time to file a modification and spend attorney's fees litigating this. Now, if they got a significant bump in their raise, or if you lost your job due to COVID or something else and you have zero earning power, that would be something that the court would determine as a significant matter. So while there's no long and hard rule, really you have to look at proportionality and whether that increase would really have a significant outcome on the amount of child support. And that's something that I'm sure, as Scott said, that you can consult with any of your local Cordell offices and tell them the specific facts in your case, and they could give you an idea of whether it would be worth pursuing the matter further. As far as alimony, I get this question a lot. Alimony, sometimes people want to extend alimony if they got a shortened time. You need to be able to tell the court that, one, there's a good cause for the period of alimony being extended. For example, if you got a month of alimony and you found that you really can't make ends meet, you can petition the court to potentially extend those things. Some points, you have it where you've been given, you're the one who's paying alimony and you've been working and you've had the ability to maintain these payments, but you retire. Obviously, your income is going to decrease. That would be something where the court will say, okay, the retirement would be a significant point in your life that would necessitate the court reevaluating what's going on with your finances. And this is something that you're not doing voluntarily. Well, you're retiring voluntarily, but this is a natural course of things where you're not trying to just get rid of paying something. But again, each fact, I would just come in and schedule a consult. Every decree, every alimony award, everything is different, just like every single marriage is a little bit unique. So it's hard to give long and hard rules, but that's why we have consultations.
Absolutely. All right, let's get to our lightning round. Arnett, I'm going to stay with you. It's going to come right back to you. Real quick question from Charles, albeit in Georgia. You can just give your information on Maryland. Does financial information always have to be presented by both parties, particularly in Maryland? But and if you have any other ideas in terms of Georgia, go ahead.
Well, yes, especially when you're dealing with child support or alimony. Financials are going to be crucial because one, the court is not going to have a basis to modify your child support payment or your potential alimony payment unless they know how your finances have changed. You have to prove to the court that one, what was the status of your finances at the point of the divorce decree where alimony or child support was established. The court is going to want to know what it was opposing parties' finances looking like. In Maryland, we have child support guidelines that accompany any order of the court. You're going to want to be able to bring certain financial documents such as your pay stubs, your W-2s, any other proof of any sources of income, because the court is really going to want to know what is your ability. If you're claiming that you don't have the ability to pay a certain amount because your income has changed, the court is going to want to know what your income is. Are you working hourly? Do you receive a salary? Do you have bonuses? Do you have any other income? Are you a cryptocurrency millionaire currently? That might change daily due to the market now, but the court is going to want to know what your financial health is. So I would say before you do any consultation, make sure that you get the financial documents because one, you need to know what your own financial health is. And two, your attorney is definitely going to need to know one so he or she can prepare and represent you adequately. Absolutely. And make that argument before the court.
Yep, absolutely. All right, next question. It was anonymous, just really a timeline, and I'm going to answer it. It was a timeline question in terms of what can be expected in the St. Louis area since I'm here. And obviously, everyone's tired of hearing it. I refer to it as DTC due to COVID. And that is they want to know what is really a time estimate from beginning to end, from meeting with the attorney to trial date. And it's really upside down in the St. Louis area, as I imagine is everywhere. I know there are some pockets in Cordell where they continued as normal, in some of these states, and they were having in-person hearings. As an example, it's really difficult to give an estimate now. There used to be time mandatories in place from 6 to 8 months was on an average in St. Louis County. I filed a case in early 2021. I don't have a trial date until I think it's July of 2022. That would have been unheard of before COVID. So it's really difficult. It's judge to judge right now. You have a turnover in St. Louis County of judges, new ones coming in, some being promoted to a circuit level. So it's a very difficult time as a lawyer now to give estimates, unfortunately. But you can press as fast and as hard as you can. It's really dependent upon, imagine you have probably an 18-month backlog of cases. And so we're just kind of in line. When I first started practice 29 years ago, it was not unusual to take 3-4 years. Unfortunately, that's kind of where we're getting is 1+ years, maybe 2, until they get through it. So tough one to answer. Christopher, Jim in Minnesota asks, original decree was almost 10 years ago with much higher income and high spousal maintenance was agreed to. The kids are now all over age of 18. How does Jim approach modification to reduce and or eliminate alimony maintenance?
I would, again, like Arnett has said, let's get your financials in order. Obviously, 10 years, a lot has happened. All your children are now possibly emancipated. Before you start, though, I look at your order and see if your spousal maintenance provision or alimony provision is modifiable. If that's the case, then you are going to want to present a case as far as what your changed circumstances are and your ability to earn, your possibly pending retirement, and what has your spouse done in that in the interim? As she entered the workforce, she gotten raises. What's her situation? Those are all things I would start with in getting your modification underway.
Yeah, I agree. And I think I've just met with someone on that very issue. We're about 6 years post-divorce. She's at retirement age, drawing Social Security, getting a pension. Now we're looking at, and I think Lauren mentioned, or it was Krista maybe, the floor. Everything starts over. We're looking at what the expenses were at the time of the divorce, and then we're comparing that to now. Wife or ex-wife has a live-in boyfriend, all that, all matters. So I think clearly you want to have a consult. You want to lay it all out and we'll give you good guidance. Krista, Josh in North Carolina with a consent order for child custody and child support. Does going to court to bring up violations of one portion of the agreement open up the entire document for reevaluation? That he deals with a high conflict situation in which the rules for communication are blatantly ignored, but there are other parts that wouldn't want to change at all. So really question is, Josh, is if he wants to go back to just kind of tweak some things, does it open up the doors for them to perhaps cross modify?
My short answer to that is yes, probably. If you file a motion to modify related to the communication issues that are in place, it doesn't technically mean that you are seeking to modify everything, but could they retaliate with their own motions and say, he's here seeking to modify just the parenting time aspect of this, but now because he's doing that, or in retaliation for you having filed something, generally that's how we see it. One person files something, somebody kicks something back over. We can't stop them from filing anything, and they may want to modify different terms of the agreement than you would want to modify. So yes, generally that could open it up, but you would want to make your motion to modify as narrow as is possible. If you're only looking to modify that communication area, you would focus your motion on that specific area. If you're looking to modify everything, you may want to include all of the terms that you would want to modify.
All right, Lauren, out of South Carolina, Florida, and Pennsylvania, kind of a trio of where things are. And this anonymous person uses the words permanent alimony was decreed and now retiring after 20 years of paying. Can this be remediated? And I guess that's going to obviously require us looking at the document, analyzing whether or not it's contractual, forever, permanent maintenance, or something that can be modified, right?
In Texas, there is no such thing as permanent maintenance. So, so that's a different issue to deal with. But yeah, absolutely. You're going to want to look at, is this contractual? Did I agree to permanent maintenance? Because people can agree to whatever they want to agree to. Or if it's court ordered and it's modifiable. So I think Arnett already talked about this, but you're going to want to look at, all right, I've had a change in my financial circumstances. What's my monthly budget look like? What can I afford? As well as, my spouse, what does their budget look like? Nobody was able to receive Social Security, 20 years ago, most likely. People are able to start drawing on retirement benefits, possibly. They may have gotten employment or something otherwise to be, or maybe they're remarried or something, I don't know. So you're going to be wanting to look at those financial circumstances. And something else that's important too is not delaying necessarily, because most of the time the courts are limited in their ability to backdate a reduction in support as well. In Texas, if we're looking to reduce support, the earliest that the court can backdate is either the date that, essentially the date that person was served with notice of the lawsuit or otherwise made an appearance in the case. So if something's been happening for quite some time, and you're just kind of sitting on your hands letting it happen, you're not going to be able to recoup that necessarily.
Arnett, let me throw this one to you. What happens when a minor turns 18 but suffers from a mental disability and is not capable of managing his own affairs? I guess the question becomes does the court retain jurisdiction? We may be talking about legal custody. We may be talking about a guardianship. Where does the family court play in that role?
Well, the court always retains jurisdiction unless certain things happen, either both parties leave, well, at least in Maryland, unless both parties leave the state or there's some other qualifying action. If there are children with special needs, there can be arguments made that the child still needs support. It's almost like agreements where you continue to have to pay for child support for their education if they're in college. Certain jurisdictions allow for the courts to still allow somebody to have those obligations. So we've had several cases where somebody has special needs and there's a special needs child, and it's very common that the order is still goes. And this goes back to the Resjudicata issue. If there's a child where the special needs of the child were known at the time of the divorce, this should be something that was addressed by the court during the underlying judgment. However, if this is a new development that happened, This might be a case where the court would need to come in and parties would be able to, it would be necessary for the court to be educated as to the circumstances behind the needs, whether parties have been actually adequately paying it, or whether the current support order is significant enough to actually take care of these new financial obligations that arise from this disability.
Yep. All right, I'm going to answer real quickly. The next one is we have still a whole handful, and we're going to try to do these in 30 seconds. The question really is, I've been blocked on social media by my ex. He knows by mutual friends she's posting things. The court has prohibited her from doing so. How do I request access to those? Because we know Facebook is notorious for ignoring subpoenas. I would take some snapshots, get your friends to take screenshots of everything, start using that. You could even use it in a deposition to start seeing if she will acknowledge whether or not these are things that she's posted. You may use those screenshots until challenged and they meet the evidentiary standard. The point is that judges are derailed by emotion. They're human. Sometimes they will choose to ignore the rules of evidence when they know exactly what's happening, and that's just life. So I would take some screenshots, start there, have a consultation with an attorney. All right, Krista, we're going to go to you real quickly here. Let's see. Let me go to this one. My oldest son is 15. He'll be starting high school, driving, having a job. How does this affect parts of the custody order, like requiring nightly phone calls? They will have phones. Surely they'll be allowed to choose when and if they call a parent, subject to house rules, things like that. How does that affect it when they become much older and the decree starts talking about nightly calls?
As your children do get older, generally speaking, what I see with my clients is a lot of the time you stop dealing so much with the opposing party, your former spouse, and you deal more with your child. So if your child is working, they're out driving, they're whatever, and you usually have your calls with them on Wednesdays, but that's the day that they go to work, then you may want to try and make some adjustments with your kids, see when they are available. If that is something that the opposing party is not letting you do for one reason or another, then you may want to consider filing a motion to modify to adjust those days accordingly.
Yep. All right, Lauren, quickly, Dave asks, agreed to 100% child support on Friday. At the time, she wasn't working. She went to work the following Monday for the lawyer that represented her in the divorce as a secretary. This is, the substantial change question. Is it ethical? What can they do about it? Was this, I have a whole host of questions for, in this, but what do you think?
All right. Well, so again, we're looking at, what were the circumstances at the time of the prior order and what are they now? At the time of the prior order, she was not employed and now she is. So in Texas, we don't look at the custodial parents' income. We don't look at both parents' income. We only look at the non-custodial parents' income. So if she got a job, the following Monday, that wouldn't be a material and substantial change for us, but perhaps it is in your jurisdiction. I'm not sure where you are. I know some jurisdictions look at both parents' incomes. So I think you would want to take a look at the law in your jurisdiction. Does her income actually have an impact? And if it does, her having a change in her income, that could possibly be a material and substantial change in circumstance.
Yep. All right, Krista, and the question really, I'm going to shorten this question is ex-spouse losing their job potentially a reason for her to come seek an increase in child support?
She could. She could seek an increase in the child support based off of that ground. In Illinois, we do base child support off of both the income of both parties and the amount of parenting time that is being exercised by each party. So she could do that, but the court can also consider her earning capacity. So they're going to look at why she's lost her job and how quickly they would expect that she should be able to get a new one, or they could do an imputation of income on her, meaning that they would treat her as though she's earning income that she does not actually have in hand.
Christopher, Marty is 58, X is 17 years younger, works full-time at $35 an hour. Income for Marty is about $36,000 a year. They have 3 kids, 16, 12, and 10. Marty's considering retiring early to minimize work due to COVID. They currently have, let's see here, make sure I get this to work, sorry. They currently have joint custody. The question becomes for Marty is whether or not he can get a modification to have the kids more and perhaps pay less, currently paying almost $2,000 a month.
Good question, Marty. The short answer of that is possibly yes. So it sounds like you've got a couple of issues there. As far as retiring early, as Krista said, there is a risk in modifying your child support that you could still be imputed your income from prior to retirement. However, one of the major factors in calculating child support is how much parenting time you have with your kids. And if your reduction in actually going to work allows you more availability to exercise that parenting time, and subsequently asking for more parenting time typically lowers your child support obligation. So you would want to consult to get the actual details of your case with an attorney. As far as you said, you're 58, so that's relatively close to the age of retirement. And see, yeah, you might be appropriate to seek a modification of your parenting time. Whether or not you have issues with the final say, you could throw that in the pot as well. And then you would be eligible to potentially modify your child support.
All right, as we round it out, I know we run out of time, Arnett. I'm going to give you the last question. Dale in Florida has asked about reducing alimony or eliminating it upon retirement. We've talked, generally speaking, you have to look at your decree to make sure that it is provided for such. But the question that is interesting by Dale is whether your assets are considered in determining a modification. It could be the assets that you were given at the divorce, the assets that you've accumulated, whether or not they are income producing, retirement, pension, all that. Is that considered in a modification of alimony?
In the state of Maryland, it is. When any party is asked for alimony or is attempting to either terminate or alter alimony, they have to submit something called a long form financial affidavit. And this is a sheet that pretty much asks you to write down all your expenses, all your assets, all your liabilities, so the court can actually see what your financial health is. So the court's going to see what you spend on Netflix, what you spend on gas, how much your boat costs, how much you're paying for gas, which I'm assuming is very high nationwide right now. And they're going to look to see what your health is, to see, okay, are you in a better financial position? Are you in a worse financial position? And they're going to ask the same from your ex-spouse. So the same thing, they look into your finances, they're going to look into hers to see whether she even has a need, because she could have a job, she could have gotten married, which it would be a factor in modifying alimony. Well,
that's all the time we have. Appreciate it. I know we didn't get to a bunch of the questions. We'll get to those at the next virtual town hall. We'll certainly do that. Then tune in and check out as more information becomes available for our town hall coming up in March. Thanks to our panelists, but also find us on the web at cordellcordell.com. You can find all of our virtual town halls and our podcasts on our YouTube channel. If you haven't subscribed to our podcast, you can do that on Apple iTunes, and you can check that out. Again, thanks for joining. And until March, have a great rest of the month.